Hi, everybody. I thought I would just record. I'm hoping this will be about a 10-15 minute kind of overview of where we are in the course. First thing I wanted to say was I really enjoyed reading all the memos. Some of them were the best I've ever seen. And I have graded the ones that I have received as of yesterday. And I want to make sure you know how to get your grades. And so if you're in the course, notice that I had to make this navigation menu show. If there's a time when you go in here and there's no navigation menu, then just see if you can find this little arrow to pull it out. You find any graded item under my grades. And you see here all the activities that we've had. And I usually try to go in and give my student version a grade so I know what it looks like. And so here is the Dropbox for the BFN version of the memo. If I put a comment in it, there'd be a little conversation box. And if there's and there should be a rubric, and I will put things in the rubric. I will also, in the comment box, attach the actual paper, either as a link to a Google link or an attachment, and you just click on the name of the assignment and you will get it right here. And then again, you can see the rubric from this angle as well. So I just wanted to let you know that that's what we were doing. And let's see, I thought I did a little slideshow so that I could stay organized. And the first thing I wanted to point out is I'm sorry that we're having a Valentine's Day with snow or sleet. So I have gone into the schedule and made some changes. Hopefully I've made the changes in all the different spots, but if not, let me know and I'll fix it. So on the calendar for the class, so we are here in the orange side. And we are working on these opening statements. So instead of having it due on Thursday, I'm moving that up to Saturday. And then I'd like you to do some peer review. And by the Tuesday, and then submit the revised version to me by Thursday. So we're moving everything up like half of a week, and that will then move the final BFM up to March 7th. If you run into problems because of the weather, please let me know. I put my cell phone in the syllabus, so you can contact me that way if your internet and or electricity go out. and we will definitely figure out a way to adapt. And don't worry if you're running into problems because of the weather. It's been a few years since we had a really heavy storm, and I guess I think I was not too long ago kind of bemoaning the fact we hadn't had any really good snow. I don't know. I may find myself regretting that. I made the changes also on the assignment. And again, I hope that my dates are consistent across the different places. But so here's the schedule that I'd like us to do. If you'll get the draft in by Sunday with a cover memo explaining what you want feedback on, complete the peer review by Tuesday, the 23rd, and then get a revision to me by Thursday, February 25th. So not sure everybody understood in the first pass, but my goal is that you would actually do some revision based on the peer review. I went in and looked at all the peer review that I could find. And some of you are doing really excellent peer review. And I'll be asking you to do the same basic process that I asked you before, which is think about the criteria and the things that the student has said in their cover memo about what they want to work on, and then use that as a way of focusing on what kind of feedback you should give. A lot of times students aren't sure what kind of feedback to give. And this Eli review method is a way that gives you kind of a structure for how to go about it until it's kind of like what I said about the IRAC. That is, I encourage you to slavishly follow the model until it becomes comfortable and you don't have to copy it so extremely. So we are working on this second assignment. I think I should go back here. The way I have set this course up, we're doing these 2 assignments at the beginning, kind of quick, and that's intentionally so, just to not to belabor them, but just to kind of do your best, quickly do it. You get feedback from each other, feedback from me, and then I want you to pick one of those 2 and work on it to really make it as good as possible. So this is a way to kind of give you a chance of identifying which assignment you prefer to work with, or prefer to have more time with, and to work on it, revise. As many of you pointed out, you haven't had any experience doing this kind of thing before, and so you shouldn't feel embarrassed by the fact that it was not a familiar thing, that you didn't really know what you were doing. But the way the course is set up, you can keep working on it until you have a better understanding, and then things will in fact get better. And I've already seen in several cases where people's the whole process of the of legal reasoning has shown improvements since the very beginning when we started looking at quick rights. So I just wanted to connect this next assignment, the opening statement, to the memo assignment, kind of point out where we are still using basically the same information or the same kind of skills, same kind of processes, and where we are differing. As I mentioned at the very last week, the opening statement is definitely more of a pathos statement piece of writing. You, from your experiences watching trials in movies and TV, you know that lawyers can get up there and get a very emotional pleas. And in fact, I have examples in this week's material for you to watch that way. And that makes it somewhat different from the memo. The memo was supposed to be a very rational, objective kind of thing that's looking through all the issues. We focused a lot on IRAC and on actually using IRAC as a way to organize your writing. You won't find yourself doing that with the opening statement. You don't need to do these little mini IRACs. On the other hand, the reasoning process that IRAC involves, and that is figuring out what the law is, figuring out what the facts are, and applying the law to the facts is exactly the same in this writing situation, just that you don't necessarily present it as an IRAC. One thing about the memo assignment is that its purpose was predictive and advisory, and they sometimes call it objective in the sense of you are not taking a side, you are just saying this is the side that the law suggests is more likely to win or not. Sometimes people are confused when I say objective, and they think they shouldn't come to a conclusion. But in fact, in that memo, you should come to a conclusion, and you should explain how you got to the conclusion. Because again, what you're trying to do is give your client as good advice as possible about whether or not he or she should file a lawsuit or whether they're likely to be filed against. One of the things I said over and over in my comments to people was that it's important to pay attention to all elements of the law. So we were looking at a battery law, and battery is an intentional touching. There's harm or offense caused on the victim. There's no consent and there's no privilege. And you need to address all of those. Now, some of them may be more obvious than others. In other words, some may be more arguable than others. That you found that as you were going through the exercise. For example, it's hard to know for sure that that Mr. Smith's action was intentional, but you can infer that it was intentional because he basically admits to having done it because he thought Chris Connors could take it because of the type of bar, which is, I guess, like a Hooters type bar. One of the things that many of you came up with discussed whether or not there was consent or privilege. And several people have mixed up the ideas of consent and privilege, and I've put comments on that. So his whole, Mr. Smith's point about he thought she could handle it and, he thought that's what appropriate for the bar, that's really a consent argument. He's saying that there was some kind of implied consent by her working in that kind of a place. And as we know, we can't have implied consent for touching. There has to be explicit consent. We learned that in the Me Too movement and hopefully other ways as well. Several people treated that as privilege. it's not really a privilege. Privilege is a much more narrow right or relief from an obligation, but it's based on one's category or the type of event. So we all know about, say, lawyer-client privilege or spousal privilege, or the defenses are also treated as privileges. So the self-defense law in the exercise was called the privilege of self-defense. And again, it's a specific thing of a specific category of person or relationship or situation. Several of you had to discuss the self-defense issue with Chris Connors. It is a lot easier when you work on it from the elements of the law, because that gives you a way of talking about it. So the law itself says you can claim the privilege of self-defense and as long as you use no more force than necessary and to stop further harm. And I forgot to add the third element, which has to do with a reasonable mistake. So in trying to decide whether Chris might be guilty of battery, when she basically retaliated against him, in your thinking, you go, well, was this more force than necessary? Is there some other force that she could have used to avoid the situation? Was it necessary to stop further harm? Well, that's where this timing issue comes in. So there's no evidence in the story that he was continuing to delicately touch her. Likewise, when you're discussing the sort of linear thing of events after for Mr. Bailey, it says that in order for there to be transfer of intent to batter, there had to be intent to begin with. The consequences need to be foreseeable. That is, Mr. Smith should have been able to foresee that something like this might happen, and that there's no intervening cause, something else that might have gotten in the way. And again, this leads you to, in most cases, interpret the immediate damages that he experienced as probably something that he could recover as under a transfer of intent theory. But the later consequences out in the parking lot outside of the building at a remote time are much less likely to, he's much less likely to win on, because there's a lot more possibility of an intervening cause. Maybe he was drunk, maybe while being upset might be a foreseeable consequence. He's an adult. If he's too upset to drive, maybe he needs to not drive. So I wanted to point all that out just because I want you to just kind of think about the difference between these two different assignments. So with the opening assignment, we have a different purpose and audience. You're standing in front of a trial. It's an oral genre that is delivered at the beginning of a trial. And you need to think about what that means in terms of what you decide to include or not include. At the same time, it still needs to be based on the law. And so it's really important that you become certain that you understand what the law is that you're working with. So I've given you these, and throughout the course, I'll use this. There's this woman, Margaret Hagan, who's out in California, and she has really gotten involved in making law more accessible by making it more visual. And as she says, she's interested in how design can improve the justice system. And some of that has to do with the communications that people do. So this diagram I have comes out of her visual law library. And then this communication design project is just about how all these genres within the court system might be made more communicative, more rhetorically effective. And I think this is a really interesting concept. And actually, for those of you who are graduate students, I would encourage you maybe there might be a possible topic in there for you for your graduate student paper. So in the material I'm posting this week, I have several different versions of the law of intentional infliction of emotional distress. Here's her diagram: an intentional act, outrageous and extreme, that causes severe mental distress. I've told you that you should use for this assignment the Arkansas jury instructions. And there's links, it was links in the readings from last week and links in the discussion for this week. In the textbook, there is California jury instructions. And there are also a passage, a section from the Restatement of Law Torts. A restatement is basically where somebody has gone through and collected interpretations throughout all jurisdictions across the country and tried to come up with a sort of a generalization about the law. It is what's called persuasive, not binding authority. And the jury instructions are written for particular jurisdictions, particular courts, and because of the repeated type of cases that they have, and so they're trying to make it more clear what the elements of the law are and that they have to think about. So there are several versions of the law of intentional infliction of emotional distress in the materials, but they all come down to the same thing, and that is that there are these four elements that need to be addressed. That the act was intentional or reckless disregard of the distress it might cause. The act needs to be extreme and outrageous. The plaintiff needs to suffer severe emotional distress. And the fourth thing that ties us all together, the causation element, that is that this conduct is what causes the distress. As you see in the discussion about these cases that I've been, I have repeatedly gone in and said something like, okay, so it sounds like the element you're talking about is intention, or the element you're talking about is causation. And so, like with the IRACs, I want you still to be very aware of what the law is that you're working with, and that you pay attention to the actual elements of the law. That will give you a structure for what to say and a basis for coming up with your conclusions that will be not just sort of a ramble about how terrible something is, but will be sort of focused on the particular things that you really need to think about. In the material I'm posting this week, I talk a little bit about developing a theory of the case. And so really what's different between, one of the things that's different between the memo and the opening statement is in the opening statement, you are now actually a partisan in this case. You are trying to defend your point of view or your client's point of view, whether you're defending or accusing. And when you do that, you always have to have a basis in law to make your argument. And the basis in law that you're doing is called the theory of the case. And basically it involves taking a look at these elements, whoops, and saying which ones you're going to really emphasize as you make your argument. So in intentional infliction of emotional distress, these elements are listed as all four being required. So you can't just prove intentional infliction of emotional distress if the only thing that you can find is the extreme and outrageous conduct, but you can't really see causation. You have to prove all of them. But as you work with each of your cases, you're going to find that one or another of these elements is going to be the piece that you really emphasize. And so you may find that parts of it are just obvious. Let's say the JCPenney case, it's pretty obvious from what we hear that the couple suffered extreme emotional distress. There's evidence of how it affected their job, their lives, their psyche. And so you may not argue too much about it. On the other hand, you may decide you're just going to really, really focus on that. And use that as the theory of the case. On the other hand, you may be a little uncertain about the intention of the JCPenney people. And so you may realize that that's going to be an arguable thing, and that you need to figure out a way to argue that there is clearly intention or reckless disregard of the consequences. And so you want to think about how are you going to emphasize that. So basically what I'm saying is, in preparing for this opening statement, you need to look at each of these elements and figure out how much you're going to emphasize which ones, which is going to be the real basis of the argument. How are you going to move the jury both emotionally and also rationally? Because remember, it's not just an emotional thing, that still all the law pieces have to be met. So if you're arguing that something cannot be intentional infliction of emotional distress, in some ways it's a little easier, because if you have one element that's not met, you're pretty much, all you need to do is talk about that one element. So if you are talking about something and that there's no causation, you may concede that, the parties were upset and they behaved and something happened that was outrageous. But since there's no evidence of causation, they can't be held responsible. On the other hand, if you're arguing in the affirmative that it is intentional infliction of emotional distress, you still have to focus on all four of the elements, although you may emphasize for emotional reasons, say, the outrageousness of the law. I'm not going to be real picky about what an opening statement is. If any of you have friends or family that are lawyers, they will probably tell you that what you're going to end up producing is not quite an opening statement, because it's really hard to keep argument out of an opening statement. But that's the point. The opening statement is not supposed to be an argument. It's supposed to be a preview of an argument. And so you have an argument that you're going to be making, and what you're doing is you're talking about what is going to happen during the trial. What is the evidence that you're going to present? Who are the witnesses? That's one part of it. And then the other part is, what is the law that you're going to have to show? And so that's why I started by talking about making sure that you understand what the elements are of IED. One last thing I want to talk about is this idea of case law, which may be unfamiliar for some of you. There are two types of laws in American jurisprudence. There's statutory law, which includes statutes, but any kind of written down law that is passed by some kind of political body. And then there's case law, and that's what we're working with here. Case law is developed through the interaction between cases and other cases. And what happens is that any given case, there's an infinite amount of scenarios of emotional distress that could happen to a person. And within a jurisdiction, one is obligated to think about how your new case is similar to previous cases and different from previous cases. And so the extent to which it's similar to cases that have established certain principles, that you can end up saying, this is the principle that we're going to use. If it's different, if it's distinguished from previous cases, you end up saying, no, this is not the same. This is why what you've been given here for the law in this case are jury instructions and the restatement. These jury instructions and restatements are documents that sort of codify some of all these cases that have happened. And when you look at the jury instructions, you'll see, and the restatement, that there are lots of examples. And that's because case law develops through individual fact patterns. And I'm going to ask you to use the Arkansas formulation of intentional infliction of emotional distress, its wording, and the link to that is the jury instructions for Arkansas. which actually are available through the Arkansas Judiciary website, but I've linked them so you don't have to look for them. But I've also said, go ahead and read the jury instructions from California that's in the book, and the restatement, which is actually an earlier edition that's in the book, because it has lots and lots of examples of, or they have lots and lots of examples of previous cases. One last thing to say is that these rules develop, they are binding in that jurisdiction. So that's why, say in the Arkansas jury instructions, it cites cases in Arkansas where the court has ruled one way or another. The texts that we're looking at are examples of case law. These are real cases, and these are the judicial opinions that happened, that were published on these cases. Usually what happened is there was a trial, and then somebody from the trial appealed something that happened in the trial, and then that was then sent to an appellate court, where you don't have a trial, you have a judge who is interpreting something, a judge or a panel of judges. So the Supreme Court, the appellate courts, Arkansas Supreme Court, Arkansas Appellate Court, these are appellate courts. They don't deal with trials, they don't deal with the facts. What they deal with are appeals of trials that, you know, some issue came up at the trial that somebody appealed about. Okay, so I'm hoping that that will be helpful for you. And there's also a whole lot of written material in the week 4, week 5 unit. And we will have a check-in tomorrow, but I'll probably extend the deadline. But I will ask you on in the check-in to decide which case will be your case, and then we can talk about it some more. So again, I hope nobody runs into any problems because of the weather. If you do, that affects your progress in the course, please contact me. We can definitely work things out. Okay, all right. Have a great end of the Valentine's Day.